Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murdersheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via. Content warning: this episode contains some discussion of the murder of 2 girls.
As we all know, there will soon be oral arguments before the Indiana Supreme Court concerning the Richard Allen case.
But what exactly are oral arguments anyway? How are they structured and why do they even have them? How much pressure do they put on the attorneys in the case? And how do the lawyers prepare for such a high-stakes argument? After all, if an attorney makes an error, it could have fatal consequences not just for their case, but perhaps for their entire career.
To get answers to those questions, we turn to George W. Hicks, Jr. George is a partner in the Washington, D.C. and the Dallas offices of Kirkland and Ellis, and he has extensive appellate experience. Experience which, as you will hear, includes successfully arguing a case in front of the Supreme Court of the United States.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases.
We're The Murder Sheet.
And this is The Delphi Murders. Richard Allen goes to the Indiana Supreme Court. Appellate attorney George W. Hicks discusses oral arguments.
The reason our audience is currently so interested in the issue of oral arguments, of course, is this case of Richard Allen that has been coming to the Supreme Court of Indiana on a writ of mandamus. I just wondered if you had any thoughts on that.
Well, I think that it's a very interesting way that it is before the Indiana Supreme Court. So typically, a case gets before any state Supreme Court, including the Indiana Supreme Court, after the case has essentially finished in the trial court. So there's been a verdict or there's been sort of final judgment. Then it goes to an intermediate court of appeals and there's a decision by that court. Then the losing party in the court of appeals asks for review by the state Supreme Court. So here, the Indiana Supreme Court. And so it's sort of like a multi-level process. Here, however, as you mentioned, it's called a writ of mandamus, and that's a very unusual procedural mechanism by which you can go straight from a trial court proceeding that isn't even finished. There is no final judgment, and go directly to a state Supreme Court, the Indiana Supreme Court here. And it's usually a more expedited proceeding. And usually the state Supreme Court will only step in to decide that issue if they think that it really is an important issue that needs to be decided. Because otherwise they would say, look, wait until the case is over, then bring your appeal to the Court of Appeals. Then if you lose, you can ask us then. This is a very different situation where the defense has gone directly to the Indiana Supreme Court. And even more unusual, the Indiana Supreme Court has decided to hold oral argument on it, which means that at least facially, they think there's something there, or maybe more precisely, they think that there's an important legal issue here that needs resolving one way or the other, whether it's for the prosecution or for the defense.
Can you tell us a little bit about yourself and your legal background?
Sure. So I have been practicing for about, coming up on 14 or 15 years. I am actually originally from Indiana, Indianapolis, Indiana, to be exact. Born and raised there, 18 years, and then went off to college, off east, and didn't really have any plans to go to law school then. So I went down to New York City for a year and did some investment banking and made it a little bit in that, and then decided that I really didn't like that. Went down to Washington, D.C., and I worked at the Department of Justice as a paralegal for a year to sort of dip my toe into the legal world, and found that I really liked it. Took the LSATs somewhere in there, went back up to Boston for law school, and really took to that and really enjoyed it, and ended up doing a clerkship after law school, which, as some of your audience may know, is something that some folks do after law school to work for a judge and get a real inside baseball understanding of how courts work. And I happened to clerk on the District of Columbia Court of Appeals, that's a federal court that hears appeals from the federal district courts. Clerked for a judge named Janice Rogers Brown. After that, I did another clerkship, this time for Chief Justice John Roberts at the Supreme Court of the United States. And he would want me to make sure that I called it the Supreme Court of the United States, not the United States Supreme Court, because that is actually its official name. I did that for a year, which is pretty typical to do a clerkship just for 1 year, particularly at a federal court of appeals or the Supreme Court. It's as you can imagine, it's a pretty demanding job, and it's almost a 24-hour, 7 days a week job. So 1 year is about the most that anyone can last there. And then I actually stayed in Washington, D.C., and went off to practice and fell into litigation and specialized a little bit more in appellate litigation. So I predominantly, since starting out after my clerkships in 2007, have predominantly done appeals. So that means that I typically do work in the courts of appeals, whether it's in the federal courts of appeals or the state courts of appeals, going up to the Supreme Court of the United States, also the state Supreme Courts. So obviously every state has its own Supreme Court that is at the top of its system, and the Supreme Court of the United States is at the top of the federal system. And I don't do a lot of work in trial courts per se, in the sense of arguing before juries or going out and doing discovery or that sort of thing, or talking to experts. What I will do in the trial courts is work on motions, particularly dispositive motions that have to do with excluding an expert, seeking summary judgments, maybe asking for judgment as a matter of law after there's been a jury trial, because those are all sort of questions that implicate legal questions, less so factual questions. So I guess if I had to put a summary of what it is I do, it's typically legal type questions and less so factual type questions. So it's going to be stuff like, is a defendant entitled to the counsel of his choice as a legal question, not did so-and-so do it or not do it, that sort of thing.
What sort of experience do you have actually doing oral arguments?
I have pretty extensive experience. I have to think about how many oral arguments I've done. I mean, I've argued at the Supreme Court of the United States successfully. I have done maybe over 30 arguments in the federal courts of appeals, have argued before district courts, have argued before bankruptcy courts. So really all levels of the system, but predominantly in the courts of appeals, and have been doing that, for over 15 years, I guess, by this point. Haven't made it back to Indiana to live, but always proud to be from there.
For our listeners who may not be familiar with our legal system or may not have that familiarity with those oral arguments, could you describe how they typically are, how they proceed, what exactly they do, just kind of as a basic summary?
Sure. So I think to give an answer to that requires explaining a little bit about the appeals process, the appellate process, because it's very different from the trial process or what you often see in movies or on TV shows. Obviously, movies and TV shows, even the trial process is very different than real life. But the appellate process is even more different than trial process. So when you get to an appeal, whether it's before a court of appeals or a Supreme Court, you're not really typically dealing with fact issues in the sense of, did this or that happen or not? Did this person intend to do that or not? What you're typically dealing with are legal questions. So you kind of take the factual record as a given, and the factual record would have already been developed in the trial court below. That could have been through discovery. There could have already been a trial. There could have already been a jury verdict. And depending on what happened in the trial court and what the decision was, that's pretty much the factual record that you're stuck with. There are not new facts at the appeals level. And that's pretty important. So there's really no witnesses at the appeals level. There's no experts. Nobody's taking the stand. There's no jury. All there really is the factual record that already existed below. And then there are all the legal questions. And so the legal questions are going to be things like, okay, let's assume that the facts are what they are. And based on those facts, is there liability for something? I'm going to try and come up with an example off the top of my head, but suppose that you have a employment discrimination case, and it's been established below in the trial court that the plaintiff who is brought suit knew about the discrimination in 2021, and it's now 2024, and the question is, so there's no dispute about the facts. The trial court has already determined that the plaintiff knew about the injury to him on January 1st, 2021. But the only question now is, okay, does that allow that person as a matter of law to bring a lawsuit in 2024? If, let's say, the statute of limitations was 2 years, but they have an explanation for why there should be an exception to that. Maybe the defendant fraudulently concealed that fact or something like that. So there's no dispute about the facts. There's no dispute about when the plaintiff knew something, when the defendant knew something. The only question is, given those facts, can this lawsuit proceed? So those are the sorts of legal questions that judges are deciding at a court of appeals. Now, they could be deciding, very rarely, did the lower court get the facts right? Because usually in a lower court, there's one person's version, the plaintiff's version or the state's version, and then there's the defendant's version. And a jury or a judge or somebody decides which version is correct in their minds. And usually that is pretty solid when it goes up on appeal. But you can still challenge that to say, look, there was just no evidence to support the jury's finding that, that the plaintiff knew about this on January 1st, 2024. But typically, what you're going to be arguing at a court of appeals are going to be questions of law. And the way that those are set up is, so you've got your decision, something happens in the trial court. Somebody brings an appeal, and there are all sorts of rules and requirements about whether you can even bring an appeal at a certain time. So not every decision by a trial court can just be immediately appealed, because the courts of appeals don't like to deal with what they call piecemeal appeals. They don't want to deal with 20 different appeals from one case. They'd rather pretty much the whole case go all the way through, and then at the end, there will be an appeal. And now there are exceptions to that, and one of them we'll talk about today. But typically, once you've got your decision that has been appealed to a court of appeals, it's a pretty straightforward and streamlined process. The party that's appealing, who's typically called the appellant, sometimes called the petitioner, but usually called the appellant, files a brief, and that brief contains all of the arguments for why the lower court got it wrong. And then the other side, who is called the appellee, sometimes called the respondent, but usually called the appellee, will get to file its brief that explains why the lower court got it right and why the opening brief is wrong. And then typically the first party, the appealing party, again, the appellant, will get to file one more brief that's called the reply brief. And so you've got the opening brief, the response brief, and the reply brief. And then after that, it depends on the court and the case, but generally the court will then have oral argument. And it's based on the briefing that it got, in addition to the record that was established below. So remember, I referred to that factual record. That's kind of in place. And then you've got the briefs by the parties. And then you're going to have oral argument, usually. And after oral argument, typically the court will issue a decision within a few months. Sometimes it can be faster than that. Sometimes it can be longer than that. Sometimes the court will ask for more briefing. Maybe an issue came up during oral arguments that it wants to know more about, but that's typically the process. It's a lot more streamlined and procedurally consistent, I guess is the way I would say, at a court of appeals, including a state Supreme Court, than it is in the trial court. Trial court's very freewheeling, lots of things are happening, things move really fast. Court of appeals, it's pretty much opening brief, response brief, reply, oral argument, decision.
I think one question a lot of people might have at this point is, why even have the oral arguments? Why aren't those briefs enough? What is a court looking for?
It's a great question. And often courts, well, not often, but it is certainly the case that a court won't have oral argument after it receives briefing. That's especially the case at the intermediate court of appeals, whether it's in the federal system or in a state system. Most states and the federal government have three layers. They have the trial courts, then they have the courts of appeals, and then they have the Supreme Court at the top. That's how the federal system is. That's how something like all but 3 states are. So at the intermediate level, Court of Appeals, you do actually have a fair number of cases that don't have oral argument, because you have a right to an appeal if you've lost. But sometimes, and often the case, you really don't have much of an appeal. And so the court doesn't need oral argument. It can pretty much make the decision based on the briefing. But there are certainly cases, and whether it's higher profile cases or, of course, cases that just raise issues or arguments where it would be beneficial in the court's view to hear from the lawyers and to be able to ask questions and to be able to understand the case better, because something that differentiates the courts of appeals, and I include Supreme Courts in that, from the trial courts, is the Court of Appeals is making a decision not only for that case that is before it, but it's going to be setting a precedent. And a precedent is a decision that means that it's going to be used in other cases. both by that court and by other courts and by other lawyers and parties in other cases. So when a court of appeals is writing a decision or an opinion, it has to be thinking not just about the facts of the case before it and who's going to win that particular case. It has to be thinking about the broader ramifications of the legal questions that it's writing. And as a result, many times it does need to ask the lawyers very specific or targeted questions about their case, but also, okay, if I rule for you or against you, what does that mean for other cases? What does that mean for the law in general? What does that mean for this legal issue? Can you come up with a limiting principle for what you're saying? Are we going to open a can of worms here? You'll often hear a judge ask something like, if I were to rule in your favor, how would I write an opinion? Walk me through it. And so that's one of the reasons a court might have oral argument. And it's also valuable to the attorneys to be able to either guide the court towards a preferred result, or if you hear questions that suggest that your case is in trouble, to steer the court away from it.
In a minute, we're going to start asking you about how an attorney like yourself will prepare for an oral argument. But before I do, I want to know, you actually wrote a terrific article on that subject. And in that article, you had a line that if I were an appellate attorney, I would find more chilling than anything in Stephen King. And I'm going to read this line. You wrote, "A single stray statement could mean for your client the difference between victory and defeat, and for yourself, the difference between a promising professional trajectory and something quite different." How on earth does an attorney like yourself deal with that sort of pressure?
That is chilling.
That's horrifying.
That's awful.
That's real true crime. Well, I think that it is true, and I stand by that statement. And because one of the challenges of appellate advocacy is that there's really no margin of error. You are up there and you are making statements on the public record in cases that by that point have usually gained a little bit of profile. And you are also making statements that, as I alluded to before, are going to be used not just in your own case, which is, if you say something wrong, bad enough, but you might say something that is used to establish a precedent that just undermines maybe your client's broader interests or the industry's broader interests, or a class of individuals' broader interests, in a way that obviously all arguments are, even in the trial courts and jury arguments and et cetera, are on the record and are public. But the fact that you're doing it in a court of appeals that is going to be writing a decision that is not just for your case, but for all attorneys and all judges and all jurisprudence, really does kind of heighten the stakes. And for that reason, there's really no substitute for, and we'll go into this about preparation, but there's just no substitute for preparation. This is not the place to sort of make stuff up or to try to kind of elide a question that you might be asked. Sometimes you just have to say, I don't know the answer to that question, Your Honor, because that's a better answer than trying to estimate something or giving your best guess and having that be a very unfortunate, even if inadvertent, admission or concession. So yeah, I mean, there's certainly there is definitely an aspect of having the spotlight on you and having your arguments have to be prepared in a way that is different than when you're arguing to a jury or even to a judge in a trial court.
So given how important being prepared is, can you talk us through what prep work looks like for an attorney getting ready to make one of these oral arguments, just given how important it is to really be precise and on the ball?
Well, there is no substitute for thorough, exhaustive preparation. I think you have to be familiar with and understand a number of different aspects of your case and the law. So number one, you have to know the record cold. And when I say the record, I'm referring to the factual record, the facts. So what does the contract say? What does provision Roman 2-7 subsection B say? What does subsection E say? How does it relate to Roman 5? I mean, you need to know that contract cold. You need to know the facts of the accident cold. You need to know every single thing that you can and keep it all in your mind and be juggling it and have a facility to be able to immediately go to the page in the record. So when a judge says, oh, what does that subsection say exactly? I don't think the language says that. You want to be able to know exactly where to go and be able to point out to the judge that he or she is mistaken about something, or that you do know where it is. And when you have a facility with the record, I think it also gives you a lot of credibility with the judges. I've seen a lot of times when you have a question from a panel of judges about something in the record, because they don't know the record. They've got dozens of cases before them. So they're looking to you to assist them in the record. And there's almost nothing worse than that 30-second pause where somebody is trying to flip through a binder, trying to find the provision that the judge was asking about. And then the pause gets longer and everyone in the courtroom starts kind of fidgeting, and the pause gets longer. And you can see the nervousness just taking over the lawyer. You don't want to be that person. You want to have the record, if not in your head always, then at your fingertips. But then that's just the first part. Then you need to know the law cold. So you need to know everything about the cases in that area of the law, the cases that you have cited in your brief, the cases that the other side has cited in its brief. You need to know how good your cases are, and you need to know their weaknesses and be ready to anticipate any questions about possible holes in your citations. And you need to be able to do the same affirmatively and proactively with the cases cited by your opponent. But you also need to know it's not just a case of memorizing your cases and their cases. You really have to have a fluency and a facility with that whole area of the law, because the judges are not as likely to ask sort of factual or historical questions about a case, because they've read the cases. That's their playing field. They know that stuff. They need your help on the record. They don't need your help as much on the cases, but they're going to press you on the cases because, again, they're trying to figure out, how does your case and a decision that we're going to write in your case fit within the landscape of existing law? And if we're going to take it one step further than the existing precedent, how does that work with the cases you've cited? Or if we're going to scale it back, do you still win? So you have to have almost a facility to kind of do somersaults and backflips with the case law and be able to speak fluently about it in a way that isn't just regurgitating, but it actually is showing that you understand this area of the law and you can help guide the judges to the right place in the law.
So what kind of a tone do you try to strike conversationally with the judges?
Everyone's practice is different. I certainly try to take exactly a conversational tone and to speak with the judges in a way that gives them confidence that you know what you're talking about. And when you can speak conversationally, almost like, hey, I'm the expert in this area of law. You're also experts, maybe not in this area, but we're a bunch of people here who talk about the law. So let's talk about it. Let's talk about this case and that case. And I'm not just going to sort of answer a question that you have and then wait for your next question. I'm going to take your question, I'm going to answer it, and then I'm going to kind of move on to a theme that I wanted to talk about that your question raises, Your Honor. That's a good point. And that brings me to another thing that I want to say. So I think one of the skillful aspects of appellate advocacy is not just to catch the ball and throw it back, but it's to engage in a broader conversation with the judges in a way that keeps them engaged and also helps you keep control of the conversation so that maybe you're not really letting them get an opportunity to ask a question that you might be concerned about. And you're always kind of keeping it on your playing field, while of course still you're not going to cut them off and you want to give them opportunities to ask questions, but sort of in the same way that we're doing right now. I mean, you asked a question, and every time you've asked a question, I've given you an answer, but then we kind of talk about things a little bit more, and you don't want to be long-winded, of course, and you want to answer the question, but you also want to be able to do it in a way that is always advancing your position before the judges.
Is it a good idea when it comes to the weak points or possible questions you don't want to get to in your argument, to identify what those may be and what the kind of holes in what you're saying are going into it? And is that a better way of dealing with it, knowing what the other side is going to bring up and being able to anticipate that in any way?
I think that it depends sometimes on first who goes first. So sometimes you're going to be the appellee or respondent, and the other side is going to go first. And so you're going to have an idea already of what the judges are thinking about the other side's case, but also your case based on the questions they're asking. And so if you're in that position, you kind of make a judgment call on the fly when you go up and give your argument. If you want to start out rebutting some of the points that seem to land a little bit more with the judges, I generally wouldn't do that. I wouldn't start off kind of with your foot in the bucket. You want to be able to give your strong affirmative argument, but if you see that there is something that is troubling one of the judges, then you do want to be able to pivot to that and address that, because if it goes unaddressed and you're just talking about your affirmative points over and over for 10, 15, 20 minutes, you've kind of done yourself a disservice, because there's something out there that at least one judge is concerned about. Now, if you're going first, you're going to make probably more of an affirmative argument, but you already know, based on the other side brief, what some of their stronger arguments might have been. And so you might end up weaving that into your affirmative argument. You might sort of pause, and if you think that you've kind of made your point on your affirmative points, you then say, Your Honor, that I do want to address what I think are 3 points that the appellee tries to make in its brief that just don't match up with the case law, or something like that. Or, of course, you can just wait for a judge to bring it up, him or herself. It kind of just depends on the quality of the briefing and the arguments, and whether you think that there's something that a judge is going to want to know. And so it's better to preemptively raise and rebut that on your own terms, rather than to have a judge ask it in a more pointed way.
Is it useful to have practice sessions, either formally with a moot court or just informally talking with your colleagues or a spouse or whoever?
So I think that there is no better preparation than doing a moot court. At least one moot court, as closely in style and format and substance as it will be to the real thing. There's no substitute for having people who can be mooters, so mock judges, and who are coming to the case who don't know anything about the case, just like real judges. I don't find it as useful to have people who worked on the case also be your judges, because they know the ins and outs and they know the strengths and the weaknesses. I think there's no better preparation than to have 3 other lawyers, ideally appellate types or people who are litigators, obviously, read the briefs fresh, just like judges will, and then ask questions based on that, because you will get questions in a moot court that you never thought of, that you had no idea would occur to anyone. But that's because you've been living with the case for months or years, and it's so helpful to have that outsider generalist perspective. I find it a little less helpful, but people have different approaches to this, to have an informal prep session where you're kind of talking about the issues and talking through things. I find that to be helpful after a formal moot court, where you can kind of do a debrief and talk about answers to questions that maybe you didn't have great answers for. But I think that's kind of should all be done before the moot court, is when you do the prep and when you are asking the questions of your colleagues who know about the record or might know that area of law particularly well. And then you come into the moot court and you want the hardest mooters you can. You want people who are going to be intimidating and put you on the hot seat for an hour. And that's what people do when they're in the government. That's what people do at private firms. It's just so invaluable to have that preparation. And you have someone write down the questions, and then you look at those questions afterwards, and you figure out what you could have said better. You figure out what themes you might want to reevaluate based on those questions. People can have multiple moot courts, kind of depends on what the actual argument's going to be like. But I think that there's no better preparation for an argument than to do a moot.
Then I'm curious, and this may be a difficult question to answer, but you talk about getting to know the record, getting to know all of the cases, doing things like moot court. Roughly how many hours of prep time does it take to prepare for an hour of oral argument?
Well, I will say an hour of oral argument is pretty unusual. That will only typically occur at the Supreme Court level. So the Supreme Court of the United States typically has hour-long arguments, and even then you're only arguing for 30 minutes. And typically in the federal courts of appeals or state courts of appeals, you might get 15 minutes, which actually is almost more challenging than half an hour, because you're trying to talk about a case that could have been lasting for years and maybe 5 or 6 legal issues in 15 minutes. But, when it comes to preparing for even a 15-minute argument, I mean, that could be 60, 80, 100 hours of prep work, because again, it's all about knowing every date, every record page, every single thing that happened in that case. And it's about knowing everything about every case you've cited and what the other case cited. So it's an extraordinary amount of preparation for a very short amount of time, which again, I think just kind of goes back to the elevated stakes of appellate litigation and oral argument in a court of appeals or Supreme Court.
You talk about all of this level of detail you need to know. I recall in the article you mentioned something about preparing a cheat sheet. What sort of things would you recommend an attorney put on a cheat sheet?
So I use a cheat sheet as the only thing that I will bring up to a podium. And I think what I referenced in that article and what I typically do is it's just a manila folder that has 4 sides to it. And I've typed out my notes and I put them on there. So I really only got 4 sheets. And I see sometimes people will go up with binders and tabbed pages and yellow pads, and they're scribbling. And I just find that, number one, I think it's distracting to the judges when you go up there with 5 3-inch binders. And number two, I think that kind of signals that you're not there to have a conversation with the judges. Like I talked about earlier, if you go up with just 4 pages on a manila folder, you are essentially committing yourself to having memorized most of everything and also being there to talk with the judges and not simply just answer questions. So the types of things that I would put on that sort of cheat sheet would be maybe 6 or 7 bullet points of the main themes that I want to get across, or the main points that if I had 30 seconds to talk to you about this case, this is what I want you to know about it. And those could be factual points, those could be legal points, those could be policy points about why it's a good idea to rule in our favor because of the broader repercussions. Often I will put some key record sites on there. So if we're talking about a contract case and the contract is 100 pages long, I want to be able to know exactly where in the record the 7 key provisions are so that I can look down very quickly and say, oh, Your Honor, that's at record 1340 if you're looking for that provision. And they appreciate that, and it makes you sound like you have real credibility. I will put some key cases down, and I will talk about the takeaways from them, and I will maybe put some of the other side's key cases and just jot down some of the limitations on them. So it's 4 pages. You should be able to fit a lot in there. And if you need more than 4 pages, then you're probably not going to be using it as a cheat sheet. You're probably going to be using it as a crutch. And you're not going to be talking with the judges. You're going to be answering their questions or talking at them and not really engaged in the type of advocacy that is best.
You've touched upon this with a number of your answers, but I was wondering, in your view, what is the worst mistake an attorney can make during an oral argument?
I think the worst mistake an attorney can make during an oral argument is to say something or give an answer that is essentially made up. Whether that's a factual answer or a legal answer. If a judge asks you something and you don't know the answer, the better response is simply to say, Your Honor, I don't know the answer to that right now. I'm happy to submit a letter about it afterwards and then move on. Or say, but I don't think that's relevant, Your Honor, because of X, Y, and Z. Or, but your question takes me back to another question that your colleague asked. So to say something that you don't have support for is only going to get you in trouble. Number one, you could be flat out lying to a court, which is in no one's interest, particularly your own. You're an officer of the court and you have to be honest before the court. But even if you're just kind of coming up with something, the other side, number one, could call you out on it when they get back up. They might send a letter to the court saying, so-and-so said this, and that's completely wrong. And here's the case that shows that, or here's the record site that shows that. So now you've got something in writing that points out how wrong you were. You also risk the judge following up with another question that is painting you into a corner based on a representation that you just made that you don't have backup for. So now you're 2 in the hole, and at some point you're going to reveal that you've just kind of lost all credibility. So if you don't have an answer to a question, you really just need to be honest about it. Now, hopefully you don't find yourself in that situation because you prepared, or you are able to parry that question in a way that is both respectful to the judge, but gets you back on track to your arguments. But you just don't want to go up there and kind of flail and swing wildly if you're not prepared.
Is the atmosphere usually pretty congenial and collegial, or have you ever seen things get tense or even hostile between the attorneys and the judges?
It is generally pretty collegial. I would say that typically appellate advocacy and appellate practice is far more collegial, both between the attorneys. It's hard to get all riled up about hypothetical, abstruse legal questions. It's not like we're talking about discovery where people are accusing people of hiding stuff and, making my life miserable. I know you made us work on a weekend because you guys screwed up, et cetera, et cetera. It's generally pretty collegial, and the judges are as well. These are the people who get appointed to courts of appeals, and the people who generally argue before courts of appeals they're not your slash and burn types, and they're they're not your fire and brimstone. They're generally kind of dorky and nerdy, and they spend a lot of time in the law library, reading law books, and so there's not a lot of kind of fire and brimstone. However, certainly there can be fireworks. There are certainly judges who are known for not suffering fools and not taking, and they know when they're kind of getting snowed on an answer, or the lawyer is dodging them, or the lawyer's not being forthcoming, as I alluded to before. And you will definitely get some judges who can really press on an attorney. Now, it almost never gets personal. And I think everyone kind of knows that the judge is doing his or her job in firmly pressing on the advocate, and the advocate is doing her or his job in pushing back, sometimes firmly. There's nothing wrong with being firm towards a judge and stating your position clearly and sticking to it and saying, with all respect, Your Honor, I just think that's incorrect. I think that's an incorrect reading of the law, and I don't think that the record bears that out. You take a different view, but I would refer you back to record 1343 and so case. And so you can kind of move on if the judge gets hostile. And certainly there's an element to the practice of appellate advocacy where when to give in, when to move on, and when a judge just isn't going to be moved on something and just kind of needed to get it out, and then you move on. And you kind of also know ahead of time who the judges are who are more likely to have a little fire in his or her belly.
Just from a personal level, from your own experiences, what is it like to argue before I'm going to get this right, the Supreme Court of the United States?
Yes, well, it is unparalleled. It's a wonderful experience. It's the most preparation I've done for arguments ever. I think I even stayed in a hotel the 3 nights before the argument just to completely isolate myself and kind of be in the zone, maybe 2 days before, because I probably had a moot court. That is a particularly singular experience because you've got 9 justices that you're dealing with. So most courts of appeals have 3 judges. Even most state Supreme Courts the Indiana Supreme Court, for example, has 5 justices. It's pretty rare that you're going to be before a court that has 9 justices. Sometimes you might argue before an en banc court of appeals, so you'll get the full 12 to 15 judges there, but that's very rare. The Supreme Court of the United States has 9 justices, and you also have argument for usually 30 minutes. And while it can fly by, you're getting hammered for 30 minutes because you've got people who, talk about writing an opinion that's going to be looked at by other lawyers, other judges. They are writing, they're writing their opinions for the ages, for the history books. And so they need to know every single last aspect about your case. And so you need to know every single last aspect about your case. And it's the biggest courtroom you'll probably ever argue in. It's a very, very large courtroom. Obviously, it's recorded and it's heard by thousands and I suppose millions if they ever really wanted to get around to listening to oral argument. So that margin of error that I talked about earlier, it goes from infinitesimal to 0. And but before you know it, it's over. And it's really the preparation and the style of advocacy really isn't that much different from arguing before other courts of appeals. It's just sort of on steroids because you've got, instead of 3 people asking you questions, 2 of whom may not really care that much about the case because, well, you've got a right to an appeal, and this is just another one of the thousands of cases we have to hear every year. The Supreme Court took your case because it was interested in the case, and it has to decide your case, and it has to decide it in a way that will affect every other case in that area of law. And so it is every justice is paying attention to the case. Every justice has read the briefs very carefully. Every justice has 4 law clerks who have read the briefs very carefully, and know everything about the case. So it's the same basic principles of advocacy, but amped up to 11, as they say.
Criminal defense attorneys sometimes talk about how difficult it is to wait for the verdict. And for them, usually they have to wait hours or maybe days. And as you've indicated, sometimes after an oral argument, you may have to wait months to find out the decision. How do you deal with that? Is that a difficult wait?
It's a difficult wait, except that there's nothing you can do about it. So you sort of just have to move on to the next thing on your plate. I imagine it probably would be a little bit more difficult to wait for a jury verdict because it's coming in the next 2 to 5 days, and you're going to have to activate once that verdict comes down. When you're waiting for an appellate decision, you kind of know nothing's going to happen for a month or two, and so you just sort of have to move on to the next item on your list. It can be frustrating the longer it goes on, because then you start wondering, and your client starts wondering, hey, what's going on here? Why is this taking so long? Remember that one question they asked? Do you think they're hung up on that? Maybe there's another case that came out somewhere so you start having these mind games a little bit about what on earth could be taking this court so long. But 9 out of 10 times, it was all just, you'll never know why it took them so long, but they'll just issue a decision. And maybe you won, maybe you lost, but there'll be no explanation for how in the heck did this take 9 months? It's a 7-page opinion. But they're very busy courts, and every judge is overworked, and the courts of appeals are overworked, and even the state Supreme Courts, even though they get to decide on how many cases they're going to take, they're overworked. And so you just sort of have to accept that there's going to be a wait time. Now, the only court where, as far as I know, they actually do have a time in which they get all of their decisions out is the Supreme Court of the United States. At the end of every term, by the end of June, and I think there was one exception during COVID when they went into July a little bit, they get all of their decisions out by the end of the term at the end of June. So that's really the only court where you are essentially guaranteed to know when you're going to get a decision by. Every other court, you just have to wait. And I have seen cases where people wait over a year from a court of appeals for a decision. And it can be very frustrating because so much is waiting on that opinion. Maybe things have been delayed in the trial court because you're waiting on that opinion. Maybe the outcome of that opinion, one way or the other, is going to have a massive effect on the trajectory of the case or other cases. And I can't tell you how many times a client says, can we call the court and ask what's going on? And the answer is always the same. Sure, we can call them. They won't tell us anything, but I'll call them. We call them. They don't tell us anything. And that's what we tell the client. So only the judges and the staff know for sure.
Got to speak to the court's manager.
Yes, and I'm sure that they get so many phone calls from, and even in high profile cases where they are getting calls not just from the attorneys, but from the general public. And, they almost need to have a recorded line that just says, stop calling. We will issue our decision when we issue it.
Before I ask you our final question, I'm sorry, this has been driving me crazy and I've been so curious about it. Over your shoulder, is that a picture of a saint right there behind you?
Yes, that actually is a picture of St. Thomas Aquinas.
Knew it. Oh my God. I was like, that it's blurry, but I'm Catholic too. So
Well, there you go. Yes, that you are the first. I've done a lot of Zooms, and you are the first person who has ever noticed that. That's very impressive. Yes, Aquinas, Thomism, Dominicans, all that sort of stuff. I referred earlier to being dorky and nerdy, so throw a little 12th century Aquinas in there, and you've really got yourself something.
Love that. I love that so much. Oh my gosh. I was like, oh, this is gonna be so embarrassing if it's not, but I gotta shoot the shot, you know?
You got it. You never know until you ask.
Yes. Here's a question though. Here's our final question that we always ask everybody. Is there anything that we didn't ask you about that you wanted to mention, or anything that you think it's important to understand? Or if there's more information on the subject that people want, where can they get that?
Sure. Well, I think you asked great questions, so I don't have too much more to offer, but I will say that for the folks out there who are interested in oral arguments or oral advocacy, particularly at the Supreme Court levels, there are websites out there where you can literally go and listen to a Supreme Court argument going back 60 or 70 years, sometimes even earlier. The website's called Oyez, www.oyez.org. And you can go there and you can literally listen to arguments when Chief Justice John Roberts, was a young government attorney and he argued before the Supreme Court, or Justice Kagan, or all of these people who, you could listen to Thurgood Marshall argue the civil rights cases. Some of these people who are just extraordinary oral advocates, and to hear the way that they present arguments. Even just for some of them, the sonority of their voice. It's really educational. It's entertaining, and it's actually kind of awe-inspiring. The fact that you can listen to these great orators who went on to do extraordinary things, or even people who just argued one time in a particularly important case. So if there are folks out there who want to know more about this, or just listen to some of these great arguments, that's a website where they can do it, and it's really fascinating. You'll go down the rabbit hole and stay there for hours.
Very cool. Well, thank you so much. We really appreciate it, George.
Absolutely. Thank you for having me on.
We want to sincerely thank George for sharing his time and great insights with us.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.